Good afternoon, everyone. Welcome to this international webinar on the topic From Reform to Resilience Guide to Corporate Insolvency. Today, we have with us our President of the Institute of Chartered Accountants of India, CA Charanjot Singh Nanda, sir. Welcome to you, sir. We have with us CA Gyanchand Mishra, sir, who is the Chairman of Insolvency and Valuation Standards Board. CA Rajesh Sharma, sir, who is the Vice Chairman in absentia. Dr. Ashok Mishra, sir, who is the chairman of Indian Institute of Insolvency Professionals of ICI, our IPA of ICI. We have with us Mr. Sajeev Devara, sir, who is the one of the panelists of the today's session. We have Mr. David Kerr, and we also have with us Mr. Ashok Kumar from Black Oak, Singapore. Welcome to you all, sir. I also would like to welcome Mr. Rahul Madan, Managing Director of Triple IPI of ICI. With this, I would request Gyanchand Mishra, sir, to give the opening remarks. Welcome to you, sir.
Thank you very much, Sarika. Very distinguished and honorable President of the Institute of Chartered Accountants of India, CA Charanjot Singh Nanda, sir. Three very eminent speakers in this today's international webinar, Sajeev Devra, sir, Ashok Kumar, sir, and David, sir. Chairman of Triple IPI, Ashok Mishra, sir. MD of Triple IPI, Rahul Madan, sir. Secretary of the committee, Sarika Madam, and her entire team, and all respected participants. Good afternoon to one and all. Friends, at the outset, I welcome all of you in this webinar, which is based on international trends and which is, of course, of very importance. We understand that insolvency is one of the growing field of the practice for the various professional in India. The law and code is evolving. So many changes and judiciary pronouncements are paving the path of the practice of the law in the country. A lot has been done and a lot is yet to be expected. We understand that there are so many countries where the law has made its full footprints to make major reforms in terms of the insolvency and valuation. In our country, we are witnessing so many reforms after it has come about 7 years ago. Friends, certain things which yet to be addressed is one of the delay in the insolvency proceedings in the country. The judicial pronouncements which are paving the path need to be introspected, need to be realigned for the insolvency professionals. Role of the COC, which has been immense in resolving the issues of the insolvency, need to be again readdressed. The equilibrium point where the powers and duties of the insolvency professionals are to be seen vis-a-vis to the powers of the COC. So many challenges, so many opportunities are on the way for the insolvency professionals in the country. We are happy that in India, more than 67% of the insolvency profession is being undertaken by the chartered accountants. So indeed, it's a great pleasure that the profession has taken one more arm and one more feather in the area of practice. I am sure that the coming time as the economy is boosting and the financial restructuring is growing in the country, I'm sure about it that there is a lot of role for the chartered accountants in practice who have adopted this profession. I'll not take much time. I'm sure about it that this webinar, where more than 2,000 participants have joined so far, is going to have very fruitful discussion with respect to various aspects, major developments, and of course, the endeavors where we could put in order to make truthful reform in the interest of the profession at large. I once again welcome all the respected participants, very learned speakers, MD Triple IPI, and most importantly, the President of the Institute of Chartered Accountants of India, Charanjot Singh Nandaji. Thank you, Sarika.
Thank you so much, sir. Now I would request Dr. Ashok Mishra, sir, to give his remarks. Welcome to you, sir.
President, ICAI, Mr. Nanda, Mr. GC Misra, Chairman of the committee, Sarika, Secretary of the committee, Mr. Devraji, eminent speaker in the field, and his much learned man, Mr. David Kerr, who will provide us UK perspective much better, Mr. Ashok Kumar from Singapore, a great learning place for insolvency. And my dear participants, sisters and brothers. Now, Triple IPI and ICAI has selected a very good topic, and let me tell you that this webinar can give a limelight both to the IBBI and MCA. Now I can tell you what is our success story in IBC in India is virtually settlement. Settlement means mediation. Although the Mediation Act 2023 has come recently, but you see through mediation, settlement has put more than 10.78 lakh crore money into the economy. That is the settlement figure. Now, through the court and tribunals, we have recovered so far up to March 25, 3.89 lakh crore. Court settlement, court, this thing has resulted into disposal of 1,194 cases for the same period, while settlement has resulted more than 30,000 cases. So recovery is, I think, more than 3-4 times, while the number of cases we have sorted out are more than 26, 27 towns. So the time has come for the government also to consider mediation. And let me tell you, this mediation is not uncommon. Even in US chapter 11, which deals with this, the all non-core issues has first to go through this process. So a strong recommendation, but let me tell you, whenever there is a delay in disposal, this is one of the reasons where the tribunals are forcing also impliedly to the parties to go for settlement, because simply putting the organization into deadwood is not of much use. So that is one of the factors. Being an ex-member of the bench, I am telling you about this. Both in NCLT and NCLAT, I have seen. So this is one of the reasons, because Sairka raised this issue at one point. Now arbitration is not allowed in India, but in non-core issues it is always allowed. It is compulsory. And our most of the cases are in non-core issues, creating more problems for having a proper way out. Now, there are certain areas like group insolvency, on which committee was set up by the government of India in 2019. That committee also given a judgment. I can tell you from my experience, I was the author of the NCLAT judgment on Videocon, where I have seen what messed up was there. Haircut was 95%. With 95% haircut, if the banks are going to lose 95% of their money, only God can save the country. So I strongly recommended that. And there the case was, the fund borrowing was done by one company and fund was being transmitted to another company in a foreign land. So in that case, I strongly suggested for a group insolvency, and I suggested this requires to be relooked by the committee of creditors and others. And incidentally, Honorable Apex Court hold good the same judgment. That has now coming to the cross-border insolvency. Cross-border insolvency, section 234, 235 is there. But let me tell you, the two model judgments, that is SBI versus Jet Airways India Limited and Compuse Infocom Limited. These are the judgments which highlights even in the current position, no even a foreign creditor can file the case under section 7 and 9. So what is the problem today is how to retrieve the assets in multi-lands unless you adopt ancestral model. Ancestral model is a very open thing where you can moderate your laws keeping in mind your public policy of that country. But this is a gray area and something needs to be done. There is also a need for a creation of a global insolvency data depository, because then only most of this thing will be elicited. Coming to the point that what I have seen in a recent study by one of my scholar conducted, she was from Nalsar, Hyderabad, navigating the twilight zone. Why the companies are falling into this, and when they are falling, what are should be the director's responsibility. Now the directors, you can say loyalty, although the law is silent, needs to be changed from shareholders wealth management to the creditors interest, because you have borrowed money and creditors are also needs to be protected being as one of the stakeholder. So some framework on this also needs to be appropriately considered and legal safeguard be provided. Let me today tell you, Indian IP profession virtually is in danger zone. Whether it is IIPI, whether it is ICSI, whether it is ICMA, IP. The lot of people either wants to leave this profession, or they are not paying fees. They are telling they are not earning. Now, how can they pay the fees? So, this mediation, if it is brought into operation, it can give a lot of input to all of. So my suggestion particularly is to save the IP profession. The IBBI should adopt, should suggest, or should make some framework so that all the non-core cases are to be mediated by the arbitrator, by the IPs. Now this is, I know that. Hello, Mr. Madan, are you able to hear me?
जी, we can hear you.
Oh, so now I will like to suggest through this platform that the time has come when we should also consider IP's profession, because now NPA as a block has come down. So naturally in the process it has come down the volume of work for the IPs. If mediation comes into force, it will give them some life. Although it is good for the economy, NPA block coming down, but it will again be generated in next 5 to 7 years. So time being, it is good for the economy, bad for the IP, but we have to strengthen this profession. With these few words, I will, and I can tell you IIPI is doing a great thing in this context. They are discussing with IB, BI and MCA and trying to suggest lot of things which will be of much help, not only to the IP profession or to the IBC, but to the economy also. So through this platform, I will also convey to Mr. Nanda that your this company is trying to do lot of things. So far, they have issued more than 20 best practices and they have done a lot of research work. With these words, I wish all the best for the webinar, and it will be a great learning to my fellow sisters and brothers. Thank you. Jai IIPI, Jai ICAI, Jai Bharat. Thank you.
Thank you so much, sir, for your address. I would now request C.H. Arunjot Singh Nanda, sir, who is the president of the Institute of Chartered Accountants of India, to deliver his keynote address. Welcome to you, sir.
A very good afternoon, ladies and gentlemen. Shri Ashok Mishra, Shri Sanjeev Deoraji, Mr. David Kerr, Mr. Ashok Kumar, the chairman of the board, C.A. Gyan Mishra ji, Rahul Madan ji, Sarika Singhal ji, a very good afternoon to all of you. I am truly honored to be amongst you this afternoon, and I'm pleased to join you all on this webinar on From Reforms to Resilience, Global Trends in Corporate Insolvency, organized by Insolvency and Valuation Board of ICI in association with Indian Institute of Insolvency Professionals of ICI. The topic of today's webinar is both timely and forward looking as we continue to strengthen and refine our insolvency ecosystem in alignment with the international best practices. As we all know that the Insolvency and Bankruptcy Code 2016 is a landmark legislation that placed India firmly on the global insolvency map. It has laws adhering to internationally accepted standards, which we have been doing. We have now carve outs for international IFRS, International Financial Reporting Standards. The code overhauled the existing regime relating to insolvency and bankruptcy in India by emphasizing a time-bound resolution of delinquent debts and, and eliminating the distorted incentives. So to put into the right perspective, the IBC 2016 has proved to be one of the most significant reforms in India. It has driven a behavioral shift among both borrowers and creditors, contributed to the conversion of substandard accounts into standard accounts, improved the quality of financial reporting, and led to a reduction in non-performing assets. To address the emerging need for speedy reforms in corporate insolvency resolution regime, the code has undergone multiple amendments in a short span. A quick look at the IBC statistics highlights its success. 8308 CRPs have commenced by end of March 2025. Out of them, 6,382 CIRPs have been closed. Of the CRPs closed, the CD was rescued in 3,624 cases. Look at the statistics, of which 1276 cases have been closed on appeal or review or have been settled. 1154 cases have been withdrawn. 1194 cases have ended in approval of resolution plans, while 2758 have ended in orders for liquidation. These figures reaffirm the code's institutional strength and its evolving impact. Now, a global perspective. Globally, corporate insolvency regimes have seen a significant transformation in recent years, driven by challenges such as the COVID-19 pandemic, geopolitical uncertainties, and monetary tightening. These events exposed vulnerabilities in traditional insolvency frameworks, prompting jurisdiction worldwide to shift towards resilience. Key reforms emphasize early intervention, business continuity, and streamlined restructuring. There is growing preference for debtor in possession models, pre-packed insolvency frameworks, and out of court settlements that preserve value and protect jobs. Noteworthy trends include the adoption of classroom cram-downs as seen in the UK's Corporate Insolvency and Governance Act 2020. I would want you to refer this, and the EU Restricting Directive. Simultaneously, jurisdictions are investing in digital infrastructure using data analytics, online claim portals, and AI tools to enhance transparency and efficiency. Furthermore, insolvency law is beginning to intersect with ESG principles, where restructuring efforts are judged by their wider impact on communities, employment, and environmental responsibilities. Further, selection criteria for insolvency professionals have been made more robust, and disclosure requirements around resolution plans have improved COC decision making. Trends indicate a mature ecosystem. Liquidation cases are decreasing and resolution outcomes are improving. A study by IIM A study by Bangalore found a 3.3% reduction in the cost of debt for firms post IBC resolution, showcasing how resilience in process translates into lower financial stress and increased credit access. Looking forward ahead, the IBC's latest quarterly newsletter outlines continued focus on CARP cost controls and other aspects. In essence, the global shift is not merely about fixing financial distressed businesses, but about building a resilient, inclusive, and sustainable insolvency framework. India is an active participant in the global evolution, and today's discussions represent a vital step towards strengthening our shared knowledge and regulatory vision. I extend my best wishes for enriching discussions and a successful webinar. Thank you and wish you all the best. Thank you. Thank you so much.
Thank you so much, sir, for this address. We would like to also thank you for sparing your valuable time and give the statistics to the viewers. Thank you so much, sir. With this, now I would like to hand over the session to Mr. Rahul Madan. After giving a small introduction of the speakers today, we have with us Mr. Sanjeev Deora, who is a chartered accountant with having 25
For session, madam, and would request you to kindly allow me to move on because I have another meeting line. Thanks for inviting me. It was a great pleasure. Thank you. Thank you so much.
Thank you,
Thank you so
President
much.
sir, for your precious time, sir.
Sir has 34 years of experience in corporate and related economic legislations, turnaround and restructuring of business, debt structuring entry strategy for overseas investors, mergers and acquisitions, takeovers, issue of new capital, and identifying vendors for new project investment. Sir is also listed on the panel of arbitrators maintained by ICAI. He appears before courts, tribunals, and regulators in corporate and economic laws insolvency professionals. So I would like to give only a brief introduction. If I am leaving something, the way you will discuss, people will know about your qualities of. So sorry for missing out something. Now I would like to invite Mr. David Kerr, who is an experienced insolvency practitioner and consultant with a career spanning in both large and small chartered accountancy firms. He is JIEB qualified and an insolvency appointment taker. He has played a key role in regulation of insolvency practice. He served as CEO of Insolvency Practitioners Association from 2008 to 2018. He has contributed to parliamentary committees chaired by the IVA Standing Committee and currently serving as member of the Chartered Institute of Credit Management Technical Committee. He is also a recipient of Chartered Institute of Credit Management's Meritorious Service Award and is also active as a charity trustee and consultant. He is basically from United Kingdom. Now we have with us Mr. Ashok Kumar, who has more than 20 years of experience in legal practice, specializing in corporate structuring and insolvency. He is highly experienced Singapore lawyer and has been noted in many reputable legal publications. He acts for companies, creditors, financial institutions, banks, and insolvency professionals, providing advice on solutions when companies are in distress or near distress situation. He is very much involved in many thought leadership initiatives in restructuring and insolvency law and practice, including the Law Reform Committee of Singapore Academy of Law, Director of the Insolvency Practitioners Association of Singapore, board member of the Singapore Global Restructuring Initiative, adjunct lecturers, SMU, and various positions in Insol and International Insolvency Institute. Welcome to you, sir. With this, I would now hand over the session to Mr. Rahul Madan and also would invite Sanjeev Deora sir for his address. Welcome to you, sir.
Sure. Thank you, Sarika ji. And without waiting further, we will quickly move to the technical deliberation. I'll just add to whatever has been said already very, very usefully and meaningfully. We have heard the inaugural comments. Thank you very much for the comments, dignitaries. And in terms of technical deliberation, the context remains that India is leaping forward in terms of our newer frameworks that we anticipate to be implemented in near future, be it cross-border group insolvency, mediation, or the pre-pack insolvency for the larger segment, and there are fewer finer points as well. So in that context, today's webinar will deliberate on global developments, and certainly India has a lot to learn from these global developments and nuances to be understood. With that, I'll simply and quickly hand over the dais to Mr. Sajeev Deora and let him explain us the context in his own word, and then he'll guide the technical derivations. With that, over to you, Mr. Deora, and thank you very much.
Good afternoon, everyone. I'm grateful to IIPI and the Institute of Chartered Accountants for this opportunity to address my fellow friends. I'll only add one thing to Sarika. She said I could possibly have an opportunity to correct. 34 years is now 42. Probably you have an old CV. So the work has changed, profile has changed. Anyways, it was in 1984 that I started my practice as a chartered accountant in January 84. So it's a very interesting subject, reform to resilience. Reform is always there in the laws. You know, we've had insolvency laws earlier. We had provincial insolvency laws and we had the other insolvency laws. So the new code of 2016 put everything together in the context of today's times. The laws will always take the shape of socio-economic conditions in a society. And that's what the Insolvency Bankruptcy Code tried to address. It's given rights to lenders, it's given rights to borrowers. So you don't have a law only for lenders or only for borrowers. It's trying to create a balance between the two, giving opportunities at different stage to different stakeholders to mark their position, resolve the business, pull it out of insolvency, or let it go to liquidation. So resilience is coming with the passage of time as we see changes coming in with the requirements of introduction of new technology, new tools are there, new problems and new issues start surfacing, and maybe to curb the people taking advantage, or maybe to provide better solutions and more economic value. So can we have the screen, Sarika ji? Sarika ji, can we have the PowerPoint? Yes, we go on to the next one, please. Number 2. So I am led to state that what is your right to set up a business is also a right to close the business. Something I learned very early in my life was that capital is always considered as a scarce resource. If capital is scarce, we should preserve it. We should preserve by redirecting the business if possible, or we should allow the business to close down if we think it's not any more viable to keep running that business. Now, capital could be in various forms. It's not only money, it's skills, it's licenses, it's brands, it's technology, it's physical infrastructure that you may have. It's the employees which work in a company, that's also capital. The supply chain solutions, which are also capital. So in a recent judgment, the Honorable Supreme Court, following the fundamental rights, said protection of certain rights regarding freedom of speech, etc., which is Article 19 of the Constitution of India, which says all citizens have the right, and 19(1)(g) is to practice any profession or to carry on any occupation, trade, or business. Should have read as or. Now, the right to practice a profession is also a right to close the business. This has consistently been held in the past also, is more relevant in the light of 25(o) of Workmen Compensation Act, which permits a business to be closed. Now here, for closing of a business, there were certain troubles that the company was encountering. The matter traveled up to the Supreme Court. The citation I've given, and the two-judge bench of Justice Sanjay Kaural and Justice Prashant Kumar Mishra clarified that the right under Article 19(1)(g) of the Constitution to carry on any trade or business includes the right to shut down that business. Though it's a recent judgment, but it lays down the law which has been coming on from much earlier. The two judgments cited here of Excel Ware and Orissa Textile and Steel also bring out the same thought process. Now it says you can shut down the business, but this right is not absolute. It's subject to reasonable restrictions, which is aimed at protecting and ensuring compliance with statutory procedures. So you have to pay the workmen. The government, state government has to give you an approval, or central government has to give you an approval, and you would close down subject to those conditions. It cannot be said that you just cannot close down your business at all because you set it up. Now the law will take it over and will be closed down in insolvency. So this is a landmark point which must be considered. If you are in business or you want to close down a business or you're advising a business, you must choose the right time and a justification, which will then bring out that the courts or the authorities would consider that you are taking an appropriate decision. I was once encountered with a situation where a company wanted to close because the technology after 35 years was not workable anymore. The fuel being used by them was no longer efficient enough at that price and economical to run the business. It did take about 4 to 6 months to convince the authorities that we are not financially feasible to do this work at all. And the permissions were granted. So while capital is scarce, preserve that capital, both your money and the resources and energy, to do the business in the right form. Can we have the next slide? Now, after the IBC was introduced, we speed up to 2016. It's a living document like any law is. And it has seen some very frequent changes, but some landmark changes, which are part of the continuing reform, are interesting to note, which are, of course, based on the socio-economic conditions of our country. A 29A provision that who's qualified to be a bidder. So certain classes of people are not qualified to be bidders because you cannot be benefiting from putting the company into insolvency and coming back from behind and taking over the same business. Home buyers was defined as a class of financial creditors in a real estate development company. Now, these are very unique solutions which our law has thrown to the practitioners, to the stakeholders, and to the public at large. A significant amendment to Section 14, which is a moratorium provision, that licenses will not be suspended or terminated. If you have a telecom license and your license is suspended because you have dues outstanding, not in insolvency, you pay the current dues, your licenses will remain intact. So it's like an ipso facto clause which is being implemented in an insolvency situation where these intangible rights will not be terminated. This came in as an amendment. Outstanding social security contributions, which is gratuity, could be leave encashment, could be provident fund, whether it is funded or not, which means whether there's money earmarked in a company's accounts or not, whether the fund is set up or not, is considered as not an asset of the insolvent estate. This money must be paid. The question is about damages and interest. Certain courts have held that, yes, with damages and interest. Of course, you have rights to represent to the Board of Trustees to seek waivers. That's a different situation. But then entire social security contributions will always be paid is a major shift in the entire thought process towards insolvency, because the courts have laid down the standards that these liabilities, whether they exist in terms of money or not, must be paid in priority to everything else, because this is not an asset of the company. You've deducted the money out of a payment to be made to the employee. You have your own contribution. Pay that money regardless of insolvency or not. Another recent amendment was the Cape Town Treaty for Repossession of Aircraft, which was introduced that aircrafts could be repossessed if they are on leases. Otherwise, it was becoming very difficult for Indian or airlines operating in India to take on aircrafts. If they would go into insolvency, how would the lessors take repossession of the aircrafts? So India has become a signatory to this treaty. A development which took place as a result of the Supreme Court judgment, the case of Rainbow Paper, was what happens to an outstanding, which is a statutory charge created on the assets? Is that liability a secured liability? The judgment was yes. If there is a statutory charge in terms of sales tax, VAT, or any other liability which is payable by an entity, it will enjoy the status of a secured liability and would sit to the secured creditors to take on decisions, also if so invited to these meetings. The amendments that got implemented, or I would say the provisions which got implemented or got amended, introduced, was pre-packaged insolvency, though not much used. I'm sure over a period of time, people will realize that an early reference for insolvency is something which is ingrained in the prepackaged solution and therefore should be looked at more favorably. The fast track corporate insolvency resolution process is there. Voluntary liquidation of companies. You had no option to liquidate companies except declare them defunct. So now a process through voluntary liquidation is available. The personal guarantors to corporate borrowers. This amendment got made, and the personal guarantors to corporate borrowers could be proceeded for insolvency proceedings before the same court where the corporate borrower is being considered or being examined, and also those guarantors would then participate in the same process. I come to the next slide, please. These are some statistics which, to some extent, have already been. There's some statistics which have already been seen. Thank you. They've already been reviewed to a certain measure, but then this data has been taken from the NCLT website and is most recent as to 31st March 25. A Section 7 reference between 2016 and now, there have been 7,800, which is by financial creditors. And these have been resolved before admission, mind you. 7,000 cases resolved before admission. Section 9, including transfers from High Court, which is the old winding up provisions under the Companies Act, 22,000 cases in all resolved. Section 10, resolved before admission. So this total number is $170 billion if I was to convert to US dollars. It's a large, staggering amount, which insolvency law itself has caused the debtors to come forward and resolve themselves before the proceedings could open. So is it the fear of insolvency? Is it understanding that insolvency is more effective? Is it trying to understand that insolvency would make us into dispossessing our business, and therefore we must resolve the creditor, like the president of the institute had mentioned earlier? It's giving more credibility to the creditors. The creditors have a place to sit in front of the borrower. It's not that the borrower is only sitting and creditor will be standing. We move to the next one. So this is also information downloaded from the NCLT website. It's only for the last 3 years that I'm presenting here. But if you look at the bottom one, which is the IBC resolution, don't be misled by the star because it doesn't refer to anything which is relevant here. But $23 billion was the amount involved in 21-22, was resolved at $6 billion at about 24%, which is the highest of the other three categories wherein resolution of debts could take place. Similarly, in 22-23, this is 39% as opposed to 28%, the highest under the SARFACI. And in 23-24, this number is 28.3% as opposed to 24.7%. So IBC has been an outperformer, though a young law with less than 10 years behind it. It still is, the entire ecosystem is beefing up. The entire ecosystem is, in my view, ramping up. And these numbers would start looking better with a period of time as judgments and practices and procedures and law mature themselves into being more market-oriented. Can we have the next slide? This is again from the NCLT website. 1,288 cases been resolved through resolution plans, and the total approved amount of the plans is about $60 billion in today's current exchange rates. So you have the next slide now. Now the resilience is building up. It's not an overnight act. Because the law is performing, the numbers in terms of performance are acceptable. Changes being made to the law from time to time are becoming effective or better understood. So IIM Ahmedabad carried out a study in March 24, and they said, what is the risk of distress after the IBC has come in? So for public firms, the risk has increased by 25%, as opposed to it being decreased for private firms by 21%, which establishes that private firms are becoming more conservative and public firms are probably not that conservative as of now, as opposed to what they were before. It also brings out that insolvency law has influenced the private firms in distress to decrease long-term leverage, which means they've reduced their borrowings and secured debt. Is it the scare of the law? Is it the scare of the fact that you lose your business? Probably a combination, and the social stigma that comes with it, because there are several disadvantages that associate with you if you are part of a failing business. So same study says that private firms have a higher default probability as opposed to public firms, even though the risk of distress may have increased in public firms, but because the size of private firms is small, the probability of their failing is higher. Now, what is the same study brings out that what is the impact of insolvency law on credit dynamics of Indian firms? So insolvency has brought about more predictability to the timelines and process. Insolvency has brought about rights of lenders which can be enforced in that known or definite time frame, as a result of which the firm's access to credit, cost of credit, and borrowing choices have got impacted. The chairman mentioned that cost of debt is reduced by 4% from an IIM Bangalore study, which is for the defaulting companies. But overall, the cost of credit has reduced by 1.4% and has increased the availability of long-term credit access to non-financial firms by 2.4%. And insolvency is affecting the assets, credit, liquidity channels, and the cost and supply of credit. There's a direct correlation between them. A good insolvency law, which provides for quick resolution of insolvency, will encourage more risk-taking, will encourage more innovation, because you have an opportunity to come out of insolvency for your genuine business default. So the risk of going down under is not something that should bother you. If it bothers you, then you would take no risk. If you not take risk, there will be no innovation. And we would be coming into a slower mode in terms of growth of business. Can we have the next slide, please? Now, since there is a, how the international markets are seeing things happening, or what we should be doing in India is, of course, contextually relevant. What is the corporate insolvency market looking at? It was referred that there's an UNCITRAL model law on cross-border insolvency. It has already been adopted by 60 states and 63 jurisdictions. In India, we've not signed up to the UNCITRAL model law. So this is dealing with the cross-border insolvency situations, lays down general principles, but gets recognized by a sovereign, and then the other sovereigns which have recognized this law will entertain you unless they have an open insolvency law like the US. So India must move towards, and more jurisdictions must move towards UNCITRAL model law of cross-border insolvency, and they must sign up to it so that they come on par in terms of basic principles of insolvency. Then there is a judicial insolvency network guidelines. I'm sure my friend from Singapore may mention it. That's the origin of this guideline. It is how the courts will speak to each other in cross-border insolvency situations. It's not that, an insolvency being done in India, which has a global footprint and through subsidiaries, associates, or through holdings or shareholdings in other jurisdictions, can just be resolved in India. You need to deal with other jurisdictions. And if you have to deal with other jurisdictions, the courts must also speak to each other. And how the courts will deal with each other, the Judicial Insolvency Network lays down those guidelines. An important aspect is the public liability. In the US, they had brought on a principle of non-consensual third-party releases in case of asbestos liabilities. So whatever claims arose as a result of use of asbestos and people suffering, they said the third parties would be released and settlements would be honored, even though the debtor is not paying the money. But then such is not the case when it came into Purdue Pharma. So a non-consenting third-party release will not happen because not the debtor. So if you're not a debtor, can you participate in such a release? Can you pay off the public liability? The opinion is mixed right now, except in asbestos in the US. It's something fairly new for us to look at right now. But yes, over a period of time, as public liability claims will grow, who to hold responsible is not the debtor alone, it's the people behind the debtor, or people who have benefited from the debtor, people who have withdrawn money from the debtor. So public liability of third parties must be covered through such consensual arrangements if possible. A case in point was this Japanese company called Takata Corporation, which manufactured seatbelts and airbags. So when the company went down under and got resolved through a cross-border activity for insolvency resolution, for the public liability of defective seatbelts and airbags, an escrow or a trust fund was set up. So the claims which had not been received by that time were settled through that trust. So that's the usual process which is adopted for a public liability. Something interesting is environmental violations. How to enshrine that within the insolvency proceedings, because at times the punitive levies for environmental violations could be very humongous. The principles are that cost of remedy of an environmental breach divided by the percent of chances of discovery is the levy for such violations. To explain in simple terms, the cost of remedy is 1,000 rupees and chances of discovery is 2% that you've breached the so-and-so law. It is 1,000 divided by 2%, which is 50,000 rupees. How will these monies be recovered if the company goes into insolvency for an environmental breach? We don't have solutions right now, but then needs to be thought over going forward as to how in a cross-border situation. I mean, we had a case where a textile mill's colors and dyes used in a plant somewhere in Eastern Europe had to be disposed of. And there was a cost of disposal. So an environmental breach would take place if they're not disposed of in an environmentally friendly fashion. And monies had to be provided out of the recoveries in the liquidation process to first meet such liabilities before they could be distributed at any other stage. Climate change is causing the businesses to change. We saw that in the health and safety in the COVID period, when most of the jurisdiction brought in laws to protect businesses from health and safety concerns which had then arisen because the defaults towards creditors would take place. Will a similar situation apply towards the climate change conditions? Well, the answer is very early to give, but it'll have to be seen because climate change is something, again, beyond your control. We are all working towards making sure the climate is healthier and better, but then if the business is not able to sustain itself due to climate change, there's a landslide and the business is just washed away. Insurance is just one part of it. So how do you protect the businesses in climate change conditions? So next rule is the Gibbs rule, which talks of, it's a very old concept that a debt contracted in a state, in a jurisdiction is settled as per the rules of that jurisdiction. This was called territorialism. Then came, no, you can settle it anywhere. So today the markets are looking at modified universalism. So there are, say, mutual agreements on the basis of which a modified universalism is emerging, where countries would recognize settlements in other countries as per their public policy. This is also very material from the point of view of a sovereign wanting that state to be a global hub or a global center or an international center for insolvency. UK has enjoyed that prominent position because of schemes of arrangement. Today in the European Union, you have the Netherlands, which has got some certain such opportunities. You have the US at Chapter 11, Chapter 15 kind of recognitions. So if India also wants to position itself towards attracting the global insolvency processes and proceedings, we would need to adopt to some sort of modified universalism so that we are open. A business having a footprint in India should be able to approach the courts in India and gain recognition for its foreign businesses also, so that a common restructuring, repayment, resolution plan can be drawn up. How should government dues be seen, since government is sitting last on the table in the Indian laws and in some of the other states? Well, UK has seen some changes. They have put social security dues, the taxes, as personal liabilities of the directors if they're outstanding. But also, I may add here that in these jurisdictions, government itself is a very major applicant as an insolvency petitioner, which is not currently happening in India. Will probably come over a period of time where GST and income tax will also start filing insolvency petitions. But government dues, if they're at the bottom of the league table, there are jurisdictions which want the government to get the benefit of avoidance applications and fraudulent transaction applications. They can be pursued by the public prosecutor so that there is a logical end to such transactions, unless you get litigation financing in them. Trading insolvencies is something not really discovered in India, but then it's a very major risk. If you're an international business and you're dealing with a supplier or a customer who's otherwise insolvent and you have no knowledge about it, should you be doing health checks with your counterparties, discovering them if they're in trading insolvencies or not, is an important aspect to be kept in mind when you're doing international business. And insolvency in India is not seriously taking trading insolvencies as a starting point, but whereas in some civil law countries, it is criminal if you do not file a petition for insolvency in case you feel you cannot pay your bills within the next X number of days, which is prescribed in law. Phoenixing, to explain it simply, is, the chairman mentioned about twilight zone. So in the twilight zone, before insolvency, you could transfer your business to your son, or you could set up another firm. You could transfer it to your brother, the customers, the employees, the working capital, the drawings, designs, the relationships move on to another business. So what would be called a criminal activity in certain jurisdictions if you're doing phoenixing? There are safe harbor rules. Similarly, what should be permitted? Of course, I mean, a person who's in business of garments will only set up a garments business. But to what extent he can cannibalize the business which is going into insolvency, where he's currently associated, or his father is currently associated, or his brother is currently associated? We need to understand these conditions a bit better. Little I say about the geopolitical risk. One knows the armed conflicts which are currently ongoing, the effect on various trade agreements, the shipping routes which are affected. So how will the insolvency market look at it? Will the lenders, creditors give you a chance to survive out of it? Do they think it's appropriate to give you an opportunity? Is an aspect which, if legislatively brought into force, will assist the continuity of businesses. In the Indian context, we need the individual resident in India insolvency to be made available, the partnerships insolvency to be made available. Cross-border, Mr. Mishra mentioned about it, the limited reach of 234 and 235, there are no agreements which are currently in place. So if you have to recover money from a company in a jurisdiction which is outside India, you have to file it as a suit. An insolvent estate will never have the money to pursue such recoveries. The group insolvency is left to judicial action. Unless we get the group insolvency, the associates, the investment subsidiaries, or down the line businesses will not be protected. So you would sell investments as investments. Currently, in one of the companies where huge convertibility option in a subsidiary is sitting with the lenders, there's an issue about if you take over the main company and the lenders convert the equity in the subsidiary, which has a great value. So your investment is going to get diluted, both in terms of number and value. So the value you pay today, unless the lenders confirm that they will not convert the subsidiaries debt owned by them into equity, it will not be a lasting solution. Important aspect is about international judgments, the awards, and their enforcement. To get an order is one part, but to enforce is the real part. So if you have a judgment against a debtor in another sovereign or an award, how do you enforce it? We still have the CPC, which gives us some leverage, but then that's only restricted to, I think, 14 or 16 countries. Unless we have treaties signed up for enforcement of international judgments and awards, the processes will lead to papers and documents which may not turn to money, which may not provide the recoveries. Can you have the next slide? So what are the evolving situations? This is the last slide for me. The evolving situations are use of AI. More and more use of AI is going to help us make things look better, make us efficient, and provide solutions which have been run through large databases. Not to say a solution or an outcome of an AI analysis can be accepted on the face of it. No, you have to go through it yourself, you have to understand it, and you have to see how relevant is it, whatever is being made available to you. Because after all, it's a database. Does it really apply to your situation or not? So greater use of AI in every situation of insolvency is called for. Certain jurisdictions have made it mandatory that if there are complex situations before courts, you must run that situation through an AI model and provide the predictions which came in from the AI model, which prompted you to pursue that activity or pursue that claim or pursue the litigation. It's not that you have a complex situation, you've just come to court and now you want the court to resolve it for you. So what is the work which is done by you, the court would want to understand from you, which are the databases or models that you used, and what were the outcomes? It's like the court asking a legal opinion on the basis of which you decided to file a suit for recovery or an action or an insolvency recovery action or whatever be it. So this is an evolving situation, and at least in complex litigations, this is going to be a requirement which will be a standard fit. At what stage should directors or people in control of a business which is going insolvent should be red flagged or disqualified? Not just because you have not filed your 3 years balance sheets or you've not filed your annual returns. Have to be a lot more. The red flagging has to come at some stage so that the public databases have information that you are red flagged or you are blue flagged or you are orange flagged for so and so reasons. And of course, disqualification is something that you get to know eventually. Now, should third-party funding be allowed into avoidance and fraudulent transaction? And how should those recoveries be distributed? There's no clarity currently we have in India, at least, on third-party funding. There are a few funding agencies, but then it's very difficult to get money out of them. The benefit of avoidance and fraudulent transactions not being pursued properly is by default going to the parties who are alleged to be conniving or alleged to have participated in those transactions. So third-party funding, in my view, like in certain jurisdictions, does exist, should be permitted in similar situations, unless the government decides to take over all such transactions, be pursued by the public prosecutor like in the UK, and money goes to the government. A significant emerging aspect in India is interplay of insolvency with private law and public law. To what extent will NCLT or the IBC enable the courts, the tribunals, to deal with public law situations? You have the regulator, the Reserve Bank of India, which refers the financial companies to insolvency. But RERA doesn't do that as of now. So one is the reference stage, and second is the intermeddling. Can the property rights be upset by the tribunal in an insolvent company if there's a fraudulent transaction? Probably no, because it's a right which is now to be enforced through a court of law. Against private parties, yes, it can be. But we still need greater clarity. To what extent can tribunals make the entire process more participative for the stakeholders through insolvency proceedings itself? What some of the countries see is a light touch or a synthetic insolvency, which we don't have right now. At what stage an oversight should be provided over a company's business? The carve-out of small and medium enterprises is a universal, it's becoming a universal phenomena all over. We have that in India too. The carve-out for MSME enterprises and the promoters of such defaulting companies can bid for their businesses. Probably it has to be seen a bit more in a market-friendly manner so that MSME businesses don't become insolvent in the first place. And there's more of pre-pack insolvency, which is available to them, which is currently though in the law, but becomes more used so that capital doesn't erode by the time you have a solution. This I had mentioned earlier that countries do want the cross-border proceedings to take place in their jurisdictions. They need to have laws which are friendly to that effect. say an Indian company has, or a foreign company has got assets in India and the major business is outside India, why can it not approach the Indian courts if the insolvency lies as a result of conditions in India? And the entire corporate, which is outside of India, can also be resolved through the Indian proceedings. A lot of work has to go into it, but then it's an evolving situation. I did hear that from Mr. Mishra that profession is seeing a bit of a slow growth. So let these services be recognized by other agencies and authorities. They have been recognized by a few other agencies. And this will actually resolve also the fee issues. The fees will start looking up because there'll be a bigger numerator to access by all the insolvency professionals. Monitors and supervisors must come in insolvent situation, at least in their resolution processes, which is what certain courts or NCLT is appointing. Is there a case for joint IPs? I've had this view for some time that in certain situations there must be a joint IP. If you have joint auditors, let's look at joint IPs so that outcomes are better. It's not just one man's shoulder who's ultimately to be looked for. Well, I think that sums up my 20 minutes or 25 minutes allocated to me. I'll be very happy to have questions after my fellow panelists have also addressed everyone. Thank you. You're not audible, Mr. Madan.
Yes, I hope I'm audible. Yeah, journey so far we have been able to understand by your discourse and the direction that we may take in near future and medium to long term. And with that perspective, I think it is time to look at some of the international developments, global developments, starting with Mr. David Kerr from UK, followed by, of course, Mr. Ashok from Singapore. So may I now request David for your deliberation on the subject matter and sharing some of the key developments in UK. With that, over to you, please. Thank you.
Yes, hello. I'm very happy to do so. I think Ashok was scheduled to go next, and if he's happy to do so, I'm happy to wait my turn.
I'm okay to go first, David, if you don't mind.
Yeah, great. Okay.
Sure.
Sure. Thank you.
Okay. Good afternoon, everybody, and greetings from Singapore. Okay, so I'm here today to really talk about Southeast Asia, and I sit in Singapore. I serve the Southeast Asian market. I'm a lawyer by profession, specialist in restructuring and insolvency, and of course, we work very closely with IPs. So I thought maybe I'll start by giving you a sort of sense of the complexity of Southeast Asia. Okay, having heard Sajeev in his opening remarks, India is a big country, of course, and I've always said this in all the seminars and webinars I speak in involving Indian an Indian audience. What's relevant to us in this part of the world may not necessarily be relevant to you. Okay, and particularly in Singapore's case. I mean, from Singapore's perspective, obviously we are a very external-driven economy. Okay, so that being the case, services is a key part of our offering to the world. And in that, there are many initiatives to create services hubs. Singapore is a service hub for many initiatives. One of them now is restructuring and insolvency. Okay, and how have we done that? We've done that by a whole series of changes. But look, Southeast Asia is a very, very complicated place, right? It's geographically, it's spread out. Okay. On top of that, Southeast Asia as a whole, in terms of its history, has been colonized by all sorts of different Western countries, and with that came different legal systems. Okay. Give you an example: Singapore is English common law. Malaysia is English common law. Thailand's pretty much civil law. Although it's pretty much in its history been neutral. Vietnam is French civil law. Indonesia is Dutch civil law, right? So the concepts clash. When we talk, in the common law world, we tend to look at our law reform and our thinking in the common law context, and it doesn't necessarily work the same way in those civil law countries. Okay, and that's Southeast Asia's complexity. All right. But notwithstanding that, the economies in Southeast Asia are very connected. Okay. Singapore has a lot of trade flowing through it into this part of the world. Okay. Internationally into Singapore and then regionally into the countries around here. China's problems and difficulties with America have shifted manufacturing bases a lot into Southeast Asia. So business as a whole here is growing. Okay. So what's really been happening in this part of the world is that let's start with first by just giving you some idea about. So there's growth. Okay, there is general growth, but of course it's a measured growth also because generally there's a global sort of a weakness in the global economy. But it's doing all right, and it's a yes and no because it's also held back a little bit because of the uncertainty in the global economy, and that has affected credit markets. Okay, so I act a lot for private credit. Private credit is expensive credit, right? So interesting thing is in the last couple of years, uh, with high interest rates, okay, coming around, expensive private credit was just expensive. It was just too hard to access. It was just too expensive. And but because of the high interest rates, domestic bank liquidity was very strong. Okay, so as a result, a lot of foreign debt started getting worked out with local debt, local bank debt, and that's now coming to a head. So we think in the next 6 months to a year, there's going to be a lot of activity around Southeast Asia and restructuring. Already, some of that is happening in some countries. We did a restructuring of a Vietnamese property company called Nova Land, and we restructured the bonds out of Singapore. Okay, but I suppose the question is this: if in the Southeast Asia Compact there's a company sitting in a country that runs into difficulty, its capital structure, its capital requirements may be funded by different things: domestic debt, foreign debt, and sometimes bond debt listed, for example, in Singapore. So the question is, where do you then center the restructuring? And that's I suppose a key thing. So the success of our initiative as a country in Singapore really also depends on its strength as a financial center, right? And there we have that strength and that predictability. So when companies in the region are looking where to structure a restructure, they look at various factors, and let me just go through some of them, and this will lead into this whole question of what is the effectiveness of model law adoption, all right, and whether that can break through some of these sort of issues. So first question is, of course, jurisdiction. I mean, first, a civil law jurisdiction and a common law jurisdiction looks at the whole question of a court's jurisdiction a bit differently. Okay, and then tied with that is, if you center in one country, then how do you get that restructuring done in that country through those courts sort of recognized in another country? So how do you make the restructuring implement in the different countries in the region? So that's a big issue. Okay, not every country in Southeast Asia has adopted the model law, and I'll get into that when I speak about the specific countries, but I'm just speaking generally now. Okay, how do you manage director liabilities in those countries is a key issue too, right? We all have this very comfortable idea of how it works for director liabilities in common law countries, right? Okay, it's predictable. The common law is generally English based, and you roughly know the principles are there. But in the civil law countries, it works quite differently. Okay, and something as simple as sacking an employee in Vietnam, for example, first of all, you can't even do that. Okay, and then the implications for the directors if they do that is a problem. And it's the same thing in Thailand, for example. If you want to liquidate a company in Thailand, it's a very difficult thing to do. So the complexities vary. So where you can center, where you can recognize where the jurisdiction is going to be and how it's going to implement is a key issue. Okay. Sajiv G spoke about the Gibbs rule. I mean, Singapore doesn't recognize the Gibbs rule, It's not something we've followed the way of the US and many other common law jurisdictions to not follow the GIPS rule. So we are happy to restructure foreign debt in Singapore, provided we can get that implementation done in the countries where we need to get it implemented. All right. Now, valuation is another key issue. Okay. Here, I want to pause a little bit. Okay. There's different kinds of things that we talk about when we talk about valuation. First, there's valuation of the company, the enterprise value of the company. And I think one of the trends now is that people are looking at the value of the company in different models. You know, the typical situation when you look at a plan is to compare the restructuring offering and what it brings you to the dollar compared to a liquidation scenario. Okay. But why does liquidation scenario always have to be the option? Okay. Is there a possible enterprise value in terms of forward-looking value that you can compare to as opposed to liquidation, right? So that creditors get a better option as to how they actually see and perceive the forward value of the company. And this has a big issue because then the value of that enterprise can be allocated in a different way, right? Because fundamentally, in any restructuring, what you're doing is in a limited sort of value left in the company. You're just allocating it throughout the capital stack. And even like, for example, if you have bank creditors sitting on some sort of inflated idea as to what the value of their secured debt is, those valuation issues need to be dealt with for an effective restructuring to be done. Because then you can effectively allocate the value and then have a real restructuring done and see whether this company can really, continue or not. Okay. So valuation is a big issue, and I feel not enough thought is given into that in restructuring in our part of the world. I would say this much, having been involved in quite a number of Chapter 11 cases, in the US, they're more alive to the question of valuation and different valuation models to see how enterprise value should be cut and distributed. Okay. Of course, another factor critical to where you center the restructuring, okay, is that of whether that particular place has sufficient rule of law. Okay. Southeast Asia is quite complex in that sense. All right. So sometimes with international creditors, the comfort to center the restructuring in a particular jurisdiction, a big assessment and a big part of that comfort comes with whether that particular jurisdiction respects rule of law. Okay. And with that comes speed and predictability of outcome, right? If you have rule of law and you can fix speed, you have predictability of outcome, you have very key essential things for a very fast deteriorating company where the value in its situation where it is distressed or stressed or going through a restructuring, the rapid destruction of value needs to be addressed with speed and predictability of outcome. We grappled with this in the early days of our restructuring laws that we adopted in 2016, but I think now that's become a real priority. So we've sort of fixed that, and so predictability of outcome, speed. I think Singapore rule of law. I think that's. I don't need to get into that, but I think generally people respect rule of law here, and therefore Singapore is becoming now a jurisdiction for people to want to center their restructuring, okay? Particularly if there's debt sitting here or their assets sitting here. Now, the next thing is, of course, allied to speed is dispute resolution. Sajid Ji spoke about this. So dispute resolution in a restructuring situation is a perennial problem, right? Because dispute resolution, if you can't sort that out in your restructuring model quickly, you're dealing with legacy problems that will kick down the restructuring, destroy value even further. Company can't come out. So that's where mediation is, of course, a key issue. Like Sajid Ji was talking about mediation, and I'll share with you where we have gone with that. Okay. So of course, mediation is encouraged, okay? But mediation, as we know, is a voluntary process. It's voluntary into the process and it's voluntary out of the process, okay? So the US model has adopted a sort of like a hybrid approach to this. What happens in the US is that if a Chapter 11 judge says, look, I think this thing is ideal for mediation, and if someone applies to it, or the court on its own may direct it, it may direct parties to actually go into mediation. Okay. But so in a sense, it's involuntary into mediation, but it's still voluntary out of mediation. Then the question is, how do you prevent people just go through the motions in a mediation when they're forced to go into it, right? Forced in inverted commas, or they're pushed into it, to just say, okay, let me go through the motions and not be bothered about it. So how the US courts have dealt with this is that they look at some markers to see whether there was a genuine attempt to mediate. Okay. And if there wasn't, there may be certain consequences that flow from that, you know. So mediation is a developing area in this part of the world. I must say, in the civil law jurisdictions, the claims treatment, and even in Singapore, the claims treatment is if it's in a formal sort of restructuring model like the Singapore Scheme of Arrangement or the Indonesian PKPU, there are claims adjudication processes built into the process. And it's a sort of not an ideal sort of, it's not a full adjudication or dispute resolution. It's a process that goes through a very truncated claims adjudication process, and with some level of court supervision, but it's truncated. But it still can delay the restructuring, and I think this can be quite destructive of value and quite damaging to the success of the outcome of a restructuring. Okay. Now, the other big consideration is, of course, the question of the quality of the insolvency practitioners. Okay. So here, different countries around the region have been looking at it. I mean, I can share with you what we are doing here in Singapore. Fundamentally, what is happening here is, of course, first of all, the model is like this. The licensing is done by the government, by a government agency. All right. There's no the regulation of the professional itself, because the professional normally comes from the legal or the accounting profession. Okay. So for liquidations, lawyers can be approved liquidators and they can hold liquidation appointments, but they are regulated by the legal professional rules, conduct rules. And the the accountants, who can be both liquidators and resolution professionals for the restructuring processes that we have here, okay, they need to be approved auditors. So they're almost all of them are, in fact, all of them are accountants. So, and they are regulated by the accounting body. So we are relooking the whole thing to first try to see whether there is a way to bring some standards and uniform standards into the whole process, with that proper education, proper exams, and that sort of thing. We already started this. Insolvency Practitioners Association of Singapore has started certain initiatives, and is in dialogue with the government to see how we can assist the process. So, but the standards of the IPs are quite critical. And when I get into the Malaysian jurisdiction, I'll share with you. In a sense, I think the Malaysian jurisdiction's experience is closer to yours, although on a smaller scale. Okay. I'm not going to touch on third-party releases so much, and Sajid G's comments on Purdue. I'll just touch it. I don't know whether you're aware of this, Sajid G, but the Purdue decision, there's a bit of a controversy about whether there's a workaround with recognition. So you can actually, if you can find a way to center the restructuring in another country, okay, and then get that recognized under the model law in the US, there's a big question of whether even Purdue applies, okay? Because the public policy exception, the US bankruptcy court has, in New York, Southern District, has actually ruled that it's not contrary to public policy. Okay, so it's an interesting development. So therefore, the robustness of your own regime and its acceptability internationally is very useful to your country if you can get and earn the confidence of the international investment community and other jurisdictions. Okay. Okay. So now let's, of course, in Southeast Asia, law reform is something that a lot of countries are looking at. In that sense, we've been ahead of the curve as a country in Singapore. So we adopted our ancestral model law adoptions of cross-border recognition of insolvency proceedings, or rather, recognition of cross-border insolvency proceedings. We are now looking at possibly adopting the other model laws on group insolvency and recognition of foreign insolvency judgments. Okay, I think we feel it's necessary for us, at least as a country, because, like I said, we are an externally driven country, economy, and the openness for us is more important than looking at just domestic issues. For your country, it may be different, but for us, we are going to do it. Okay, most probably. All right. And continued cross-border cooperation between courts has now become a real priority too. Okay. Why? Because if you look at the countries in our region, okay, we are probably the only model. In fact, we are the only model law country in Southeast Asia. Okay. And what we've done is we've tried to see whether the GIN guidelines, like what Sajivji spoke about, that is an initiative we started to try and see whether we can do court-to-court cooperation, even with a non-model law country. It has, I'll be honest with you, it's had limited success. Okay, there haven't been many GIN applications, and I think for whatever reason, it's not a favored approach. But I think that may change. Okay, as more and more countries in Southeast Asia adopt the model law, I think it works better if it's a model law country. Okay, but whilst that is happening, what we have done is done a lot of MOUs with neighboring jurisdictions. So we've got one with Indonesia, we've got done one with Malaysia, we've got one with Hong Kong, even though Hong Kong is East Asia, but we've got one with Hong Kong. So, and we are expanding that cooperation, the judicial cooperation between the countries in our part of the world. Okay. So those are the sort of like the key issues. I mean, the ancestral model law and all its tools, I mean, for us, it has helped, okay, because we are increasingly being seen as a jurisdiction where we can center restructuring, and India could be the same, okay. So the model law adoption is something that and I'm going to ask Sajivji later on in the Q&A, what is the reluctance to actually adopt it? I don't really fully understand it, okay, because I would like to learn and understand this too, because in Malaysia, so let me go to the countries now. Singapore, I've sort of given you a flavor. We are moving ahead with quite a lot of law reform, already adopted a lot of law reform, and continuing to do it, okay. There's a new round of reforms coming out in the next very soon, in fact, on revamping our administration model, adopting the other model laws, ancestral model laws, and also extending certain tools that we have in restructuring to include equity. Okay, right now it's mainly debt. Okay, Malaysia is close to adopting the model law. There was a fair amount of resistance about whether there would be a loss of sovereignty. I think one of the biggest concerns when I've had the dialogues with the regulators in Malaysia, the general concern is whether is the system, financial system, and the legal system robust enough such that it will result in Malaysian companies looking away from Malaysia to do its restructurings. And I'm wondering whether maybe that's a concern that India is facing. But in the end, Malaysia came to the conclusion that if they don't go along with this in some sort of measured way, because ultimately, if that happens and it comes back to Malaysia for recognition, the gatekeeper is the court, whether there's been some sort of abuse. Okay, and the markers can be set. So Indonesia is also now, even though it's a civil law country, looking at model law adoption. So I think that's something that we are watching very closely. Ancitral is engaging them very closely. I've seen the delegations in the Working Group 5 deliberations in Ancitral, which I'm a party to for Triple I, and they seem to be very serious about wanting to do it. I think Vietnam is unlikely to do this because right now the economy is doing fantastically well. Okay, a lot of foreign investment pouring in, but there's a lot of uncertainty as to business risk as to how you actually exit. Okay, because secure creditor rights and property rights are very cloudy in Vietnam. But as a manufacturing a place for manufacturing, especially with this China tension with the US, it just cannot be ignored. So at some point in time, as their economy grows and as international investment pours in, the demand and the need to modernize their tools will come. And I think the people in charge are alive to the issue. Okay, so that's pretty much. I don't know whether I've used up my time. Am I still within time, Rahul?
Yeah, I think almost there
Okay,
towards the
almost
end.
there, almost there. So I'll leave with this parting words. I would just say that, look, what works ultimately, and I told this also to the people I spoke to in Malaysia who are behind the law reform. I think ultimately you got to do what works for your own country. Okay, I think that's a given. Okay, but I think the adoption of the model law is something that is now becoming so important to adopt. Okay, you have such a burgeoning capital markets, you have a tremendous domestic economy, you have outward investments just pouring out to other countries. So look, the time will come, like Ashok Ji also said, in the next couple of years, where there's going to be a need to relook all this when the economy does slow down. And the model law adoption is going to give you flexibility and options to actually help Indian companies, I believe, when they get into stress or distress. So I'll leave it there, Rahulji.
Sure. Thank you. I think you have been great in terms of your deliberation and highlighting, raking up key debatable points. And I'm sure we will come to some of these debatable discussions towards the end of our session. Thank you very much. Now, without waiting further, let's come to the next session and the address by David from UK in terms of his understanding on the subject matter and sharing developments in United Kingdom with respect to and in the context of what we have heard so far. Look forward and over to you, David. Thank you.
Thank you very much. And my thanks to the Institute for inviting me to join you today. It's a great pleasure to be with you. As Sarika mentioned in her introduction, I've been an appointment taker in corporate insolvency cases, although concentrating these days on consultation, but I've also worked in the two main regulators here, regulating insolvency practitioners. And I was interested in the remarks made by your president in his opening address about a vision for regulation. And I'm going to pick up that theme a little bit and share with you some of the reforms that are coming here in the UK. And I think, Sarika, if I may, you have some just a few slides that I can use during my short presentation. If they could come up now, that'd be great. There it comes. Great, thank you. I'm going to start with just a few statistics. If we could move to the second slide, please, to give you an idea of the current trends in terms of numbers of cases and the types of cases that we're dealing with here. And I've got a chart which I'll share with you in just a moment. But I mean, in broad terms, what are we seeing? The numbers of cases have returned to pre-COVID levels. and if anything now are higher. There in terms of corporate insolvency, we're currently running at about 24,000 cases per annum. And the vast majority of those, more than 90%, are liquidations. So these are closed down situations. The vast majority of them are out of court processes. And so they're voluntarily instigated by the directors of the company to put the company into a process that will ultimately produce hopefully some money for creditors and an eventual dissolution of the company and its cessation. If we can just flip to the next slide, which has the chart. So you have here some month by month, these are the figures up to March 2025 with previous March comparisons, just to give you an idea of the total numbers over that period, with the pickup post-COVID to a level now that's actually higher than it was immediately before COVID. We're back to the sort of levels we had in 2008, 2009. There was a bit of a spike you can see in 2023, but the numbers are pretty much settled at about 2,000 per month across the whole of the UK. And as you'll see, more than 3/4 of those are the voluntary liquidations that I referred to earlier. So a lot of them are small cases, low cost, low fees, unless there are recoveries made. So you've made the point earlier about the need sometimes to pursue things that might have happened pre-insolvency, where some correction is required, potentially for the benefit of creditors. And here there's been a bit of an exercise by government and by liquidators in pursuing directors for misspent COVID loans and such like, to bring that money back into the estate for the benefit of creditors. So that gives you an idea of the sort of numbers we're talking about. The numbers of recovery cases, you can see a light blue line at the bottom here, really a very small proportion of that overall total. Now, those cases are currently conducted by about 1,250 insolvency practitioners taking appointments in the UK. And I should tell you, in addition to the 24,000 per annum corporate cases that we're talking about in this chart, there are many more personal insolvency cases. We have over 100,000 personal insolvency cases every year in the UK currently. So you can see the size of that market. But those 1,200 insolvency practitioners, if we could move to the next slide, please, Sarika, are currently regulated by 3 professional bodies. And we have a system that's been developed over now nearly 40 years, I think, as we celebrate the 40th anniversary of our 1986 Insolvency Act next year. You'll be marking the 10th anniversary of the Insolvency and Bankruptcy Code. And there are some interesting parallels between our system of regulation and the one that is of a government agency providing oversight. And we have a large degree of the day-to-day regulatory activity being conducted by the professional bodies. Now, whereas I think you probably have a bit of a mixture of regulation by both the IBBI and the IPAs, we have a system that has pretty much delegated all of the functions to the professional bodies, up until now at least. And that has meant that they've dealt with the initial licensing process, they've dealt with monitoring, and they've also dealt with complaints, and even in conjunction with others, they've dealt with a lot of the standard setting, amendments to the Code of Ethics and so on. Now, some of those arrangements have over time caused people to question whether that system works as well as it might. And I was interested in Ashok's remarks about the system in Singapore, where he referred to, the best ways of ensuring that there are good standards of practice, and whether in future perhaps professional bodies might have a role to play. And I think what we've seen in the UK is potentially some retraction of that delegation. There were calls at a time when there were more regulators than there are now. At one time, there were 7 different professional bodies involved, and there were calls, perhaps understandably, for a change to that system, and in particular, whether there might be benefit in having a single regulator for insolvency practitioners rather than several, particularly given that, as I say, we've only got just over 1,000 practitioners actually taking appointments. So the process of giving some thought to change that might be needed really began in earnest in 2019, when the government sought evidence from creditors and other groups and interested parties about what change might look like. And issues such as a single regulator were floated. A number of issues arose during that process. Questions about conflicts within professional bodies, the speed with which they deal with matters, and cooperation between them, and consistency in terms of the approach to regulating practitioners. Soon after that, there was a consultation, and in that consultation, the government proposed that there might be a single regulator, and it suggested at first that that single regulator might be that same government department. Now, a lot of practitioners and others, whilst keen to see perhaps some slimming down of the number of regulators into a more manageable group, were not, it seemed, quite so keen on the government taking on that role. And certainly my experience of talking to insolvency practitioners here in the UK is that generally they would have a preference for being regulated by their professional body, by their peers, rather than perhaps by government directly. And of course it changes and it's different in different jurisdictions. If we can just flip to the next slide, please. You'll see at the bottom of that one, by the way, that I referred to a final response published by government about 18 months ago now, at the end of 2023, suggesting, as a consequence of all this deliberation, what eventually now might be put into place by way of regulatory reform. So let's just quickly look at what those points now we think are going to look like. So first of all, on the subject of whether there should be a single regulator, it's worth just repeating the point that I touched on, that the number of regulators has reduced, whereas there were 7 professional bodies involved back in 1986. That number has shrunk as those bodies which licensed only small numbers of practitioners have gradually withdrawn from the sector, and their practitioners have migrated to others. So we now really have one that covers Scotland and 2 main bodies that cover the rest of England and Wales. So partly, I think, for that reason, but also because there wasn't really any consensus around what a new regulator would look like and whether it would be more effective, the government has settled for a position where it intends to continue with the current form of delegated regulation to those professional bodies, provided that it can be assured, and it's working on the basis of discussions that have taken place in recent years, that those regulators will perhaps be more, to put it this way from its own consultation or response document, if those bodies can be swift, nimble and robust in the way that they regulate their practitioners. So they want, in short, for the processes that they undertake, primarily in relation to things like complaints, to be dealt with more quickly. They want the bodies to be able to agree more quickly any changes that might be needed to standards from time to time. And they want, obviously, for them to be able to demonstrate that they're being sufficiently robust with members so that any questions about conflict or reluctance to take action is removed from the equation. So the government is going to continue to provide perhaps even closer oversight through its government agency. It's equivalent to the IBBI. And it's going to, for the time being, pursue a version of the same delegated system that we've had before, with perhaps, by way of a big stick, a backstop statutory provision. There's going to be legislation that will provide the government with the opportunity to introduce a single regulator, should it feel the need to do so in the future. And that will be sitting there as a sort of weapon at the government's disposal should this new arrangement with the professional bodies not work as well as it hopes that it might. A couple of other things that are changing. First of all, standard setting. The government has taken the view that it should take control of the standard setting process. So if there are changes to the code of ethics or other guidance or statements of practice that might be issued from time to time, the government will control that process, will obviously seek input from professional bodies, practitioners, creditors, and others, but ultimately will decide what needs to be introduced and will manage that process and introduce those changes when necessary. They're hoping by doing that it will strengthen the SIFT system, remove some conflicts, and more importantly, I think, in this context, speed up the process of deciding upon and implementing those changes where necessary. So that's one change we're definitely going to see put in place quite quickly. And the other concerns the regulation of firms. Now, I know under the IBC, there's a process for recognizing firms or corporate entities. In the UK, it's a little bit different. So we've had, ever since 86, a process by which individual insolvency practitioners are licensed, and only individuals. And whilst there's a recognition, of course, that a lot of practitioners work in firms, and the work is perhaps generated by firms and undertaken by them, it's the individual practitioners who are regulated, and it is those practitioners who would be sanctioned if the need arose. The firms generally have avoided direct regulatory action or sanctions by the regulators because they've not really been formally recognized under the insolvency legislation. So that is going to change. There's going to be a new process of bringing those firms or corporate entities into the regulatory sphere. And there's going to be a central register, not only of individual practitioners, but all firms and corporates who are providing insolvency services. So that will be searchable by the general public. And the aim here is to increase transparency, ease of access for users of insolvency services, and also introduce, I think, a greater degree of accountability on those firms, and potentially enable regulators to sanction the firms as well as individual practitioners. So that will be a big change for us. And if we could go to the next slide, please. There are one or two other things that were kicked around during the course of this process of review that may yet lead to some reform. One of those is the idea that there might be some compensation scheme for creditors, for debtors, individual debtors perhaps in particular, and anybody else affected by the actions of an insolvency practitioner. Now, nobody knows quite yet what that might look like, who might determine what that should be, in what circumstances it might be appropriate to compensate one particular creditor as opposed to a class of creditors, for example. So there are quite a few questions yet to be resolved about how that might work in practice. So whilst at the moment there's a stated intention to introduce some form of compensation scheme, I think it's likely to be a while before we see that come to fruition. And where does all of that leave the current regime and the professional bodies, and what implications maybe does that have for other jurisdictions? I think clearly we're going to see still a regulation by the professional bodies as the frontline regulators, and they're still going to be doing the licensing and the monitoring and the complaints handling. under oversight by the government agency. But now perhaps with having had this sort of shot across the bows from government, I think that threat of the imposition of a single regulator will be rather more clearly defined going forward, and there'll be an easier option for government to resort to that if things don't work as well as they hope they might. Now, to what extent any of that has implications for the relationship between the IBBI and the IPAs in India and elsewhere, I will leave you to ponder. I would perhaps just suggest that for those of you who are practicing insolvency practitioners, that you might cherish your professional bodies and perhaps support them in any way you can in their regulatory roles. So with that, I hope that's been helpful, and I'll pass back to Rahul, I think, who's going to take us on to the next step in the
Yes, thank you, David. I think you have taken up our cause as an as an professional body, and triple IPA being the largest in India. So there are three, as you are already aware. So I
yes.
think I personally have gained some perspective. Maybe off the record of this webinar, we will try and take some more inputs how the system works. But certainly for your information, within Indian context, there are already steps taken and implemented for recognizing firms in addition to the individuals for practicing as a juristic person, juristic IP. So firms have been now taking assignments in their own name in addition to the individuals. So that has happened a couple of years ago.
Yeah.
And yes, that debate is also was alive in India some time ago, whether single frontline regulator or multiple. But as of now, things are on standstill. So hopefully, thank you very much for highlighting some of the unique perspectives. And now, since we have about 15 minutes left for the scheduled closure of the webinar, so we'll open the house for Q&A. So before I request Sarika ji and team to share some of the audience selected audience questions.
I
And
have some questions, Rahulji.
yes,
Can I
yes. Why don't you start, Ashok ji, and then I'll request Sajeev ji also to step in and
Yeah.
raise some of the debates.
I already have a question from David.
I have a question for David too.
Okay. Please go ahead, Ashok. Yes.
Okay, David. Self-regulation, okay, as opposed to government regulation.
Yeah.
How do you prevent abuse?
Well, that's a very good question, and we don't have very much time to address it. First of all, I think it's fair to say in the UK, we've tended to avoid the term self-regulation for good reason. It is, at the end of the day, a process of delegated statutory regulation. So there is already a fairly high degree of accountability by the professional bodies to the government agency. They provide oversight. They come in and check what the professional bodies are doing. And there's quite a lot of close control. So the standards that are that the professional bodies work to in their work is coordinated, and there are mechanisms in place for the government agency to ensure that there's consistency across those bodies. And also those bodies are working with a degree of input from people outside the profession, so creditor representatives and others. So there's I think there's been increasing transparency and involvement of third parties in the process, and public, publicly available information, so that when the government agency conducts reviews of the way that the professional bodies work, it will perhaps publish the outputs from those exercises. So delegated statutory regulation rather than self-regulation, with lots of checks and balances in play. What you can't really avoid is the fact that if you've got practitioners involved in a process of regulating practitioners, then there's always going to be some argument, at least, about conflicts of interest.
Yeah.
And manage that. I mean, it is manageable, and it can be managed. You're talking at the end of the day about professional people, and it should work, and it does, in my view.
Okay.
But whether it's translatable into every jurisdiction, I would agree is perhaps a question.
Yeah. So Sajivji, there's a question for you from the attendees. The question is, regarding your remarks on social security payments, how are those amounts to be paid if the company has insufficient funds?
Well, it's interesting. If there's no money, where do you pay from? There's always a clawback, which is there in every insolvency. So you have clawback monies to come in, which would be paid up. There is dispensation, which can be applied to the Board of Trustees of the Provident Fund authorities. So at least the interest and damages is looked at sympathetically. What is critical is the employee's contribution. Since monies have been deducted, they must get deposited. Employers is equally important, but employees is rather more important than the employee's contribution. So the clawback will be there in the avoidance only, but the creditor is not going to put in money back into the company if they have not received anything. Yes, I do understand what's happened in the UK is that the directors have to give in a guarantee if there's a default in social security obligations for a period of 3 months or something like that. And they don't let the defaults mount. So I was delivering a lecture to the Provident Fund Authority some time ago, and I did mention to them that you should act rather quickly. You should not let the dues mount. You should call the management to discuss the issues so that recoveries can begin, or at least the security is provided to you out of an escrow to be created, something what UK has done.
I see.
Yes, but if there is no money, there's no money.
Yeah, that's
The
right.
question they wanted to understand is can they get the ex-directors to books for having defaulted or having carried on the business when it was insolvent and not having reported for insolvency. I said, well, those legal rights do exist with you. Start your learning curve now. The quicker you ramp it up, the better it is, because the defaults will not be there.
But you need money to even do that. So, you know, so to sue the directors, you need money too. So third-party funding is what I understand from your side is not something that's developed.
Yes, it's
Here we allow it. Well, we allow third-party funding.
yeah, it's not robust there. It's not banned. It's not going on. And the serious issues are about, you assign a debt, then you would have to pay a GST, which is a VAT on the assigned amount,
Right.
which is an outgo before the money is even coming, and it's for the full value.
That's
controversy about it.
That's discouraging. I got a question for you as well, Sajid. This is I picked up something in your opening, which I wasn't sure whether I fully understood, whether I got this right, but I think you mentioned that, and you showed the stats that there a lot of people, coming out early, all right, and there's also a sort of like a sort of I don't know whether it's reluctance or a slowness to access credit markets and give out security for bank debt and other sort of credit. My question to you is this, right? Isn't this not good for the economy? Because if you can't, what does it do for the credit markets? The credit markets are necessary for scaling up the business. And that has a wider effect on the economy's growth if companies cannot scale up business. So I'd like you to hear your views on that.
Yes, I mean, that's coming from the report from IIM Ahmedabad, or Bangalore rather. That's a Bangalore report which says that if insolvency regimes do not deliver quick results, there'll be risk aversion.
Yeah.
And investment and innovation will take a hit. But mind you, we're only in the 10 years, less than 10 years of the insolvency regime. So we've had all the good, bad, and the ugly of pre-2016 getting referred to insolvency. So there's a lot of zombie companies which are seeing themselves as out of it or a safe exit to dissolution.
Yeah.
So if you were to take the zombies out of it and look at the stratified data, the analysis, in my view, will surely result in the outcomes which have been, come out of the studies. The rate of the percentage rate of credit has come down. The availability of credit has gone up because they have looked at data of the recent past.
Yeah.
And also at the same time, predictable outcomes and time frames is what you mentioned.
Yeah.
Though we may talk of 180 days, 270 days, 330 days, or 1 year for liquidation. But nevertheless, mind you, there's been 2 years or more than 2 years of COVID in between.
Yeah, that's a
So there's been
problem.
slowdown. There's been a learning curve with a new law in place from 2017 onwards. So I think we're doing pretty good, because if you
Yeah,
compare it with the other recovery measures, we stand on a very good footing under the insolvency law, considering it's all very, very recent.
that's
And
good.
there's a huge learning curve.
Actually, it's amazing. The stats are very, um, it's quite impressive. So there's a question that's come through from the delegates. How have recent global reforms in corporate insolvency law aimed to balance the creditor rights and debtor protection? Let me have a stab at this. Okay.
Yeah, you answer this. I'm coming later.
Okay, so look, this is a perennial tension, all right? And it's a function of whether the country is, how would I say, pro-rescue or pro-creditor. I mean, if you look at Singapore's journey, right? When the first restructuring model we had was after a company called Pan Electric collapsed in the 1970s. The stock market was shut down for a few days. By that time, the UK already had an administration model. That model was a creditor-led model, right? As opposed to Chapter 11, which is a debtor-led model. So the perennial question is, who should you leave the restructuring to? Okay. So the history has shown that the debtor-led process, the Chapter 11 type process, seems to be more effective. Okay. Why? Because it rebalances the, I wouldn't say power, but it rebalances things, all right, to some sort of even keel between creditors and debtors. Okay. Of course, no room for abuse, no room for fraud, no room for that kind of stuff. We're talking about real, genuine business failure. Okay. Right. So a pro rescue, I find that, and that's where Singapore has gone now. So we've kept the old model, which is the administration type model. We call it judicial management. We're trying to enhance it in the next round of amendments. But we've taken a lot of Chapter 11 tools and built it into our scheme process, which is fundamentally a debtor-led process. And I find that model seems to be more effective. And the UK seems to have gone that way too, because their new model, restructuring plan model, seems to be more like a debtor-led model. Am I correct, David?
Yeah, but it's very little used.
It is abused? Oh dear.
No, little
Oh,
used.
little used. Little used. Okay. Okay.
No,
Maybe.
I agree with you, Ashok. I mean, the rebalancing can only happen if the management, which is in default, unless it's part of a serious fraud, is retained,
Yeah.
because they know the best about the business.
Yeah.
And that's a carve out which is available to the medium and small industries in India, that
Yeah.
the defaulting promoters themselves could get back the company, provided certain conditions are qualified. And you mentioned about the US, the balancing takes place in the Chapter 11 when the unsecured creditors want an investigation into the business of the company.
That's
And,
part of it. Yeah.
and they say the proceeds of this so-called recovery is going to come to us.
Correct.
So you created a bit of a log jam,
Yeah.
and people come to table to talk census.
You see, sometimes it's very awkward, I tell you, there are some countries in our neighborhood where the predictability of outcome is not so clear. All right. But for some reason, the very fact of that lack of predictability of outcome brings people to the table to talk. It's a peculiar situation. So,
Yeah,
but
it's a function of what you expect out of your insolvency
you see,
proceedings.
this is true. This is true. So, okay, I have another question here from the audience. This is an interesting thing, and maybe David, you can have a stab at this. How have changing insolvency laws influenced the behavior of key stakeholders, lenders, investors, and resolution professionals?
Well, that's a difficult one. Well, I mean, I suppose behaviour of creditors and other stakeholders depends to some extent on that framework. I mean, we've reintroduced here not so long ago priority for government agencies, for example, unpaid social security and the kind of thing that Sajid was talking about earlier. I think as well, if you look back at that voluntary liquidation model, it's precisely because of the potential downside built into legislation for directors if, for example, they continue to allow a company to trade beyond the point when they know it's insolvent, that they will then, on advice, take the steps necessary to put a company into a voluntary liquidation process. So, because they know that the consequences, if they don't do that, potentially are greater for them personally. So that affects behavior to some extent. If there's a reasonably robust process by which liquidators can recover money from directors in those circumstances and hold them to account, it'll encourage them to, in a sense, do the right thing and put their companies into a process sooner rather than later. Particularly as well because the process, our process for liquidation happens to be an out-of-court one and therefore relatively speedily put in place and without great cost. And that's a factor too.
Okay, let me share some of the Southeast Asian experience. So it's quite a complicated scenario as everything in Southeast Asia is. So it's not so clear anymore who's a lender, who's an investor, and of course the RP is clear. Okay. The point is that a lot of debt is traded. Okay. And in fact, the violence I see is really lender on lender. Sometimes it's driven by traded debt. Okay. And then in some jurisdictions, the question is whether there's too much power given to the secured lenders, right? Because the secured lenders influence the RPs. Okay. And are they RPs really acting in all stakeholder interests? Okay. It is a question. All right. And it's sort of allied. The same question, this last question is also asked by the same person who asked about the balance. Okay. So the balance actually is at the core, right? And at the core of that is valuation of secured debt and the security. Who should be the gatekeeper for that? Who should ride the upside on value? I mean, a debt may sit at a secured debt may sit at 100 million, let's say, okay? But the value of security is, let's say, only 30 million. So effectively, the bank is unsecured for 70 cents to the dollar. So who should ride on a post-restructuring situation the upside of value is the question. And I think this is something that hasn't really been unlocked in almost every jurisdiction I see, including the US. Okay. I think US gives equity cushions. I think they're the most advanced as far as that is concerned. They give equity cushions to secured lenders and then make way for allocation of value beyond that. But Asian restructuring doesn't seem to be doing that much because it's very bank-led.
Yeah, because the bond instruments have this kind of cushions for sure.
Yeah.
The important aspect is that unless you can start holding lenders to accountability.
Yeah.
Like in India, say 70% of the banking is with public sector, which is owned by the government.
Yeah.
So to what extent you can hold them liable or responsible?
Yeah.
Once I asked a friend of mine in Germany, I said, "What's keeping you busy?" He says, "Suing banks for keeping trading insolvencies and representing to the world at large that everything's good and hunky-dory with this company." So they lend the money when the company should not have been given a dime. So
Yeah.
who is more responsible? The banks themselves, because you can recover the money from them.
But isn't that the responsibility of the regulator, the bank regulator, to be proactive on write downs and provisions? Because that happens in the US a lot. That's why it fuels and oils restructuring, because the banks, in a sense, are regulated stronger in terms of taking provisions.
Yeah, you need to get these companies or the larger companies write a living will, like the banks do in the US.
Yeah.
Every quarter there's an SEC filing of a living will.
Absolutely right. Yeah, absolutely right. Okay, I don't know whether we run out of time, Rahulji.
Yes, I think we should announce the closure, and let me with a heartfelt thanks and gratitude to all of the technical speakers, experts today. And in my own view, towards the end, we have heard a lot of nuances, finer points, challenges across the globe, and we were only thinking that it's India that we are facing challenges in, but it is actually a lot of challenges being faced even now in advanced economies like UK and Singapore, and more need for such deliberation, such exchange of ideas to understand from each other and gain from the best practices. And it is not without the reason that we call this insolvency profession as one of the most challenging and also satisfying at the same time. Personally, I have gained a lot, and before I sign off and we announce this, I'll request Sarika ji to come in towards the end, maybe a quick word and the final comment from her side. Over to you, Sarika ji, and we can now announce. Thank you.
Thank you so much, sir. With this, I would also like to thank each of the speakers as well as the participants who have been with us throughout for this 2 hours. We have around 2,000 people who are watching us live. So this is one of the good numbers of insolvency professionals who are watching us. Thank you, each one of you. Again, on behalf of Insolvency and Valuation Standards Board, thank you, each one of you. Thank you, speakers. Thank you, IIIPI. Rahul Madanji, thank you so much.
Thank you
Thank
for,
you. Have a great time.
giving us the
Bye.
opportunity.
Thank you for joining.
Bye.
Thank
It's been
you.
a pleasure. Thank you.
Thank you, sir.